So, Ms. Hunschmann, thank you very much for your highly interesting lecture that approached us also to the question why the comic has a real value added on different levels. And also one other takeaway that I took was the idea of that the aftermath is also a history of violence. So there is not only the word struggling in the context of a relationship of the survivors toward the German bureaucracy, or a struggle, an internal struggle for the survivor, but also a struggle, let's say, with his path in, as you very well described, in the little town or village he came from, and the social struggle he had in order to get documents, for example. Yeah. So a different form of struggle is that the survivors were trying to get back their property and businesses. And our next presenter is Dr. Ingo Lohse. He will concentrate on the aspect on how German restitution organization or institutions were handling cases in which a survivor and an Aryanizers put in a claim for the same property or business. Dr. Lohse obtained his PhD in 2005 on German banks in occupied Poland from 1933 to 1945. From 2000 until 2010, he was a lecturer at the Humboldt University, and since 2010, he's a researcher at the Leibniz Institute of Contemporary History. His fields of research are the history of Jews in Poland and Russia, Soviet Union in the 19th and 20th century, Yiddish literature, Nazi occupation policy in East and Central Europe, and the economic history of the Third Reich. He is lecturing today about the equalization of burdens versus restitution, post-war battles between Jewish survivors on the Holocaust and former Aryanizers, some case studies from Lower Silesia, 1936 to 1978. I would like to Mr. Lohse, Dr. Lohse, to come up to the floor and give his presentation.
Yeah, good morning, everybody. First of all, thank you for the kind introduction, and thank you to a warm thank you to the organizers and the entire staff of the conference for the kind invitation to Tel Aviv and to Israel, and for the excellent organization of everything and about this illuminating conference. The following thoughts I would like to share with you are very much a work in progress, since it is sort of a byproduct of a bigger project on the history of Jewish entrepreneurs in Breslau and Lower Silesia from the 1920s to the Holocaust. And this focuses mainly on economic counter-strategies of these businessmen and women against increasing political pressure after 1933. But in the end, all of them fell victim either to bankruptcy and liquidation or to Aryanizations. And in using the term Aryanization, I hope you will always hear the quotation marks I have here in my manuscript. Many of these Silesian Jews did not succeed in leaving the Reich and were finally deported and murdered in the Holocaust. But this also includes the topic what had been left of the significant economic share in property of the Jewish community in Breslau after the Shoah and the Second World War. And this brings me directly to some questions closely linked to this conference, namely to the Equalization of Burdens law in German LAG of August 1952 that we have discussed already yesterday evening. And yesterday, Ambassador Avital spoke of a patchwork of totally different forms of compensations. And if you recall the diagram of numerous different programs of compensations Kim Wambach displayed in his presentation, the LIG is only one tiny chapter in this entire structure from 1952 until now. On the issue as such, Iris Nachum is undoubtedly the much better expert than I am, and for that reason I'm extremely grateful for her paper yesterday and the clarifications of the complicated legal structures. As you will see, this is pretty much a grassroots history, but nevertheless an integral part of the entire compensation process, which includes not only big politics, but also the lower levels of administration, which had to put political decisions and laws into practice in the first place. In recent years, the German debates on the Holocaust as well as on the Third Reich and its aftermath have been increasingly often linked with and expressed in terms of economic origin. In the last, say, 15 to 20 years, we have seen a large number of publications about Aryanizations and Aryanizers in several cities of the Reich, who in the second half of the 30s unlawfully took over Jewish property, businesses of Jewish owners, etc. However, little attention has been paid in this context to Aryanizers who, after 1945, or rather 1952, claimed lost property in the former East German, now Polish or Czech territories. In fact, a lot more countries were involved wherever a German and a German Jewish minority had lived before the Second World War, but for now let's keep things simple. In Germany, the political debates of the last few decades dealing with the expulsion of several millions of ethnic Germans from Central Eastern Europe in the years following the end of the Second World War almost entirely omitted the fact that after Berlin and Frankfurt on Main, namely Breslau was the hometown for the third biggest Jewish community with more than 20,000 members in the German Reich in 1933. In 1937, still almost 17,000 members of the community still lived in the city, which means that in the years before, the emigration rate of Breslau had remained far below the average throughout the German Reich. In May 1937, local NSDAP party sources spoke of about 2,000 Jewish shops and businesses in Breslau alone, which seems to be a more or less realistic figure. Nevertheless, by the end of 1938, the vast majority of these businesses had been already shut down in one or another way. So shortly after the November pogroms, I tend to use the plural, not the singular, November pogroms, Jewish economic life in Breslau vanished almost entirely. I mention these figures here for one purpose, because in a moment I will have a look on the dimensions of the equalization of burden procedures and of the decisions made in favor of Jews on the basis of the LAG. So for Jewish survivors from the Reich, from Breslau in this case, the starting point was that they were often, to a minor degree, interested in any form of compensation as far as it was perceived as a merely humiliating German goodwill payment. We had that since the very first day of our conference. All the more promising was the opportunity of the equalization of burdens since 1952 to claim what had been robbed during the Aryanizations. With all justification, Jews from the former German territories in Central Eastern Europe felt themselves as the first expellees from these territories, in a certain sense even as double expellees from these lands, that is fully entitled to take part in this form of restitution. Since the LAG was designed to integrate German expellees into the West German population and therefore to provide them with sort of a seed capital, it took 4 more years until the end of 1956, when the 11th Ordinance on compensation payments under the Equalization of Burdens law was passed, and Jewish claimants as so-called fictional expellees were entitled to claim their lost property within the framework of the LAG law. Nota bene provided they could prove first that they were victims of Aryanization, which often turned out to be quite difficult, and second, they could prove their cultural and linguistic connections to German culture, or at least, as it was done later on, at least German citizenship. In the case of the lost territories in the East, one may assume that many of the Aryanizers successfully settled their claim because West German administration dealing with the execution of the Equalization of Burdens law was hardly able to conduct thorough research about the circumstances of individual ethnic German expellees, since most of the documentation had been destroyed in the war or become inaccessible beyond the Iron Curtain. But what happened if there were Jewish survivors, or close relatives, rightful heirs, etc., who were the legitimate owners of the Aryanized businesses or real estate and now too became claimants to the same companies or businesses? Those who had benefited from the persecution of the Jews in the late 30s were obviously aware that conflicts between Aryanizers and Jewish survivors would arise as soon as the political talks between the State of Israel, the Jewish Claims Conference, and the FRG had begun that finally led to the Luxembourg Agreement. For example, after 1952, an association of so-called loyal buyers of Jewish property was formed in Berlin, whose exact activities can no longer be constructed in detail, but they obviously pursued the goal of securing the possessions of Aryanizers against potential Jewish competitors, who in fact, from 1956 on, began to participate in the equalization of burdens. What happened in these cases of conflict? Which compensation office processed the applications initially depended on the applicant's place of residence, with those who lived abroad being taken on by special compensation offices. And as soon as the authorities noticed that there were two applications for one and the same property or business, the case of the applicant living in Germany, which means normally the Aryanizer, was normally handed over to the office that processed the case of the Jewish survivor. However, cases in which it turned out that several people had submitted applications for the same object could also show that the Jewish owners had several heirs, distant relatives, distant family branches, etc. So it did not always have to be the Aryanizer who made a burden equalization procedure lengthy and complicated. Naturally, the question of verification of economical and historical details in the former German territories of expulsion turned out to be particularly difficult, because in many cases the documents that could have proven the loss and damage simply no longer existed. And this was even more true for Holocaust survivors living, for instance, in Australia and being forced to provide documents from the archives. The major problem for the Equalization offices was the question on which basis the information could be verified, because there were no historians in the offices, and research on the persecution of the Jews, Aryanizations, and the Holocaust was still in its infancy. With regard to individual cases from Breslau, I must now admit that I have changed a bit my mind. First, I planned to present some examples of quite different Jewish companies from Breslau, which became the subject of conflict between Jewish owners and Aryanizers. But instead of that, and with regard to the limited time at my disposal, I will rather try to give sort of a typology of the cases I found. What did they have in common? Of course, the question arises as to whether the ethnic Germans who were expelled from the homeland were given preference over the Jewish claimants. Because of the length of the procedure and the constant need to send new documents, many Jews got the strong impression that an attempt was being made to delay their applications. And indeed, the proceedings were not a place for special empathy, sympathy, sorrow, or at least understanding for the fate of the survivors. If you disregard the bone-dry official language of the correspondences, then I cannot claim for the files I've gone through that the concerns of the Jewish owners and their heirs were not taken seriously, or that they were even deliberately delayed or complicated. On the contrary, in the majority of cases, these applications from Jewish claimants immediately led to the assumption of a history of persecution, even if the survivors were unable, for the time being or even later on, to produce any supporting documents. And this can also be learned from the angry letters from the former Aryanizers, who were already sure of their compensation payments and whose cases had now been stopped for the time being or even turned down completely. But of course, this very much depended on the personnel involved. There were also highly outrageous cases in which Jewish lawyers had to intervene when even the dumbest lies of an Aryanizer remained unnoticed or allegedly unnoticed. What repeatedly caused considerable difficulties for Jewish applicants was the fact that Aryanizations showed a very wide range, and that the rule of thumb that sales under pressure had only occurred in 1938 and later on had many exceptions. Some of the cases already involved forced sales already in 1935 or 1936, which nevertheless were also regarded as Aryanizations by the equalization offices, if the purchaser had not paid, for instance, sort of a goodwill. And this was also the case, for example, when Jewish trading companies had only supplied state customers and authorities and were now on the brink of ruin very quickly after 1933. Of crucial importance was always the question whether the Jewish owner received the money from the sale in the late 30s, from the sale of his businesses at his free disposal and not in a blocked account, etc. In the case of previously constructed tax debits, a very well-known strategy from Nazi authorities to push forward the process of Aryanizations, or if the money had been paid in full as Reich flight tax, it was generally assumed that free disposal was out of question. Problems of proving the circumstances, postal communication across the globe took months. Receiving certificates of inheritances took years, and the authorities stood between, in a certain sense, between hammer and anvil, that is, in the middle of the battle of correspondence between Jewish claimants and the Aryanizers. The results of all this was a catastrophically long duration until payment finally was made. On average, this was not a question of some years, of several years, but in many cases of several decades. An interesting by-aspect of this totally inadequate duration was that the sum finally paid to the Jewish claimants consisted, as a rule, of a smaller part for the mere loss of robbed property and a bigger part of accumulated interest due to the length of the procedure. At the very start of my research, I would have guessed that the equalization offices tended to decide mainly in favor of the ethnic German claimants and against the Jewish former owners. But are there any hints in the LAG files to assume that the Aryanizers were trusted more often than the Jewish survivors? On the basis of my files from Breslau, I would say that this point was at least not significant enough to be visible. But this does not mean that there was no distrust, just that the forms do not provide reliable information about this. And therefore, what should be more intensively taken into account in scholarship is a problem which I would call the credibility of victims. For trials against perpetrators of the Holocaust before West German courts, Katharina Stengel has recently published depressing results on exactly this constantly questions credibility of Jewish, especially Eastern European witnesses and survivors. And I wonder whether comparable issues shouldn't also be examined more closely for the LAG and, of course, mutatis mutandis also for the BEG procedures. And if you allow me a short digression at this point, I remind you that after 2002, thousands of applications for ghetto pensions were rejected by the German pension insurance with largely completely absurd and historically incorrect reasons. The same thing then happened again on the lower level of the social courts, and it took many years before the Federal Social Court in Kassel made two fundamental decisions, and later the Bundestag put an end to this with an amendment. I worked for a number of years as an expert witness for ghetto ghetto pension proceedings, and a rejection rate for over 90% can hardly be explained other than by administrative behavior affected by anti-Semitism. So if you think that there was sort of a learning process, if you might call it, in between the 50s and the years following 2002, I'm quite a pessimist, I must say. Coming back to the LAG cases, all these typologies are inevitably linked to the question about how representative these data can be. And of course, there is no final certainty about this. But since we are dealing with the third largest Jewish community in Germany before the Holocaust, these are somewhat more than just isolated cases. One of the biggest questions still open is about the amount of profiteers, about the peculiar situation in West Germany during the 50s, and of the opportunities the LAG offered to former Aryanizers. Of course, we can add as many case studies as only possible, but it would be more interesting, as far as I can see, to know to what extent the LAG was misused by Aryanizers, and to what extent Jewish Holocaust survivors were excluded from payments because they did not fit into the narrow scheme of what the law defined as being of German descent, that is Germanis, or in Germany, Volkszugehörigkeit. This is, of course, an important point Iris Nahum already made yesterday evening. For instance, I'm, for the time being, unable to say how many Jewish businessmen in Silesia who survived the Holocaust were later excluded from the LAG procedures because they had been Polish, not German citizens, which in the German East was quite common. And I remind you that even in the second half of the 30s, more than 40,000 Jews with Polish citizenship still lived in the German Reich. Since I can omit some aspects after the presentations yesterday evening, please follow me for a while, so to speak, to the basement or the workshop of such research. If we try to draw a reliable picture of the dimension of this sort of bitter competition between Jewish survivors and the Aryanizers, we cannot avoid doing scholarship in Bayreuth, namely in the branch of the Federal Archives of Germany, where the entire material of these 3 million LAG files are kept, in the Lastenausgleichsarchiv. These holdings, although a treasure trove by itself, are a good example that in contemporary history our main problem is often not a lack of material, but on the contrary, that there are kilometers on the shelves without a clue where to start. There were, and for scholars still are, 3 substantial problems. First, how to identify a business being formerly Jewish property. Aryanization most often meant renaming the business. Just to give one example, after the forced sale of a pharmacy of Samuel Pincus in Breslau, it rebranded at once at Gutenberg Pharmacy. In many cases, the reference German, as in German Women's Coat Factory, for instance, or German Hardware Factory, or something like that, can already be a first indication of possible Aryanizations. What is needed now is a more or less complete database of Jewish enterprises in order to identify what was looted and taken over by the Nazis during the 30s. Then you have to go through the entire commercial register in the years following 1938 in order to collect further data of the already Aryanized businesses. Second, the main and crucial question was whether there were any Jewish survivors or family members who had emigrated or fled earlier and who now were able and entitled to claim what had been robbed and stolen from them. Indeed, there were few cases that only Jewish claimants filed their claim, while there was no corresponding application by the Aryanizer. Maybe because he perished in the war or for other reasons. Whether in individual cases, perhaps also out of bad conscience, we will never know. In most of these cases with only a Jewish claimant, the business in question had been totally destroyed in the November pogroms and never sold but only shut down. The third crucial problem is the aforementioned fact that all these claims were linked to a territory that was no longer part of Germany but now found itself within the borders of communist Poland or the Czechoslovakia and so on. This harshly limited the options to obtain reliable information from the land register or commercial registers. In my database on Jewish-owned businesses in the broadest sense of the word, I could identify slightly more than 2,000 entries in Breslau alone for the years following 1933, and statistics of the Breslau Trade Chamber mentioned for the entire year of 1938 only 77 applications for Aryanization, in contrast to round about 700 applications for new openings and additional 600 applications for purchase of non-Jewish owned companies. Altogether, in November 1938, there were still 288 Jewish businesses in Breslau, of whom 280 were liquidated, and only 8 were Aryanized until the end of the year. Now, looking into the files of the Federal Archives in Bayreuth, I was able to identify at least 40 to 50 cases and applications in which former Jewish entrepreneurs collided with German claimants in the context of the LAG procedures. If we take the aforementioned 85 cases, which were mentioned by official sources for 1937 and 1938, 40 to 50 applicants after 1952 who, to put it bluntly, tried to cheat the German authorities about allegedly not having profiteered from the Aryanizations, give an enormous percentage. A percentage which might be even higher with regard to a possible dark figure of cases which I simply did not find for the aforementioned reasons in the archive. In contrast to that, I should add and emphasize that I've come across not a single case in which a Jewish applicant deliberately provided false information about his claim. To conclude with, looking at these cases of Jewish and non-Jewish opponents struggling for the same piece of property, we nevertheless should not forget that the LAG was primarily designed to integrate the expellees from the East into West German society. So there is no wonder that this law was maybe not the best instrument for Jewish claimants who normally, but not in all cases, lived abroad. For them too, compensation payments were urgently needed to build up a new life abroad, namely here in Israel, the UK, in the USA or Australia, which comprises the majority of my cases. However, the question is how an alternative could have looked like that would have been able, in an even better way, to help the Jews to their rights and to justice. The entire topic seems to be a long-gone story, something for the historians, if you might say, but the entire process of Wiedergutmachung without any doubt had groundbreaking long-term effects, notwithstanding all the shortcomings of the compensation for Holocaust survivors and of the BEG and LAG procedures in particular. How explosive the question of compensation can be for bilateral relations can currently be observed in Poland after the government made demands of 1.3 trillion euros on Germany. This is, of course, a topic on its own, but I wanted to present you only a small facet on the micro level in order to underline that big politics are one thing, but the results are inevitably dependent on the cooperation and day-to-day actions of administration at the micro level. For the historians, this means that there must be more quantitative research into the mass files, because otherwise numerous interesting questions would remain unanswered, be it about compensations or about social history of the Federal Republic of Germany, of the State of Israel, and for the entire group of Holocaust survivors. Thank you for your attention.